session. We have our guest speaker. Randy Kelton. He's going to teach us how he makes our government employees do their job. And we need to learn how to do it. He uses their own laws against them and forces them to comply. Randy, will you please step up?
I want to start out by passing these around. If you're doing your own legal work, you don't have these, back it up. I don't write my own pleadings. I pull them out of here. Needs this big here, or that microphone over there. Everything you need is here. Every motion, every pleading. There we go. Check, check. Okay.
There we go.
And this one is a petition for declaratory judgment. I'll get to that.
Hold it up.
Nah, this one's a whole thing. This is
hold it to your mouth.
a 130-page criminal complaint I wrote against the county I live in and the Chief Justice of the Supreme and the presiding judge at the Court of Criminal Appeals. They arrested me and held me in jail for 42 hours. We see how that works out for them. This one, Bonnie's got is Bonnie here?
Yeah, I just spoke to her a little while ago.
She's got a copy of the complaint I filed against her judge. That's an example of a criminal complaint. And this one is a petition for declaratory judgment.
I'm sorry, Mr. Ford.
This one can just about shut down any criminal complaint anybody has against you. They do everything wrong. Okay.
Is that on your website? Those, like that petition?
You gonna talk on this one? Yeah, no, I'll talk on this.
Okay. I'm gonna try to get out.
These petitions being called?
This website or one of them? It's called jurisprudence.website.
Okay, on jurisprudence.website. On jurisprudence.website, I've got all the stuff I've been doing over the last 30 years. On the, yeah, go to that one. Look, just, which one's that?
Petition for declaratory judgment and civil complaint?
Okay, that's the one I just handed out. Go up a little, there's a complaint against the governor. Anyway, just go back to my that site. If you go to documents and research, I got folders on top of folders. I've got examples in there of about everything. Criminal complaints, I've got statements in support. I won't have time today to go into how to write and develop complaints in detail. I'll go over it briefly. But before I get to that, I want to talk about how to think about yourself. You know, someone asked me today if we were in a democracy or a republic. Guys, we're in a republic. And that is important.
That's right.
When you walk into a courthouse, you are the baddest motor scooter in the building. And there's only one reason. You're not a judge, you're not a prosecutor, a bailiff, a clerk. They're all public servants. You're the master of those servants. And they better not forget it. I had one of those servants arrest me in the district attorney's office, having a private conversation with the district attorney to keep me from filing criminal charges against him.
Oh my God.
They held me for 42 hours, let me out a $500 bond, And they were real nice to me in there. Well, by the time I got to jail, they knew who I was. And they set this $500 bond, and then I filed a motion to dismiss, and they dismissed it right away. So I sued them. $400 million. You guys want to dance? I'll introduce you to the deep end of the pool. Here's how I got there. That yellow bound folder, that one is the culmination of 30 years of research. What the code says, if a policeman arrests someone for any reason, with or without a warrant, they are to take you directly to the nearest magistrate and explain themselves. That requirement has been in law since 1216 AD, when the Dukes drugged King John down to the River Thames at Runnymede and threatened to cut his head off if he didn't sign the Magna Carta like he promised to do when they helped him defeat the French. In that document, if a policeman or a sheriff arrested a free man for any reason, he is to take him directly to the nearest magistrate and explain himself. And it wasn't because they didn't trust the police. They didn't want the public to fear the police. They didn't want them to think that the police could arrest and imprison. They could arrest, but they did not hold the key to the jailhouse door. In Texas, we have those same laws. 14.06 on a on-site offense, 1516 on a warrant. Both of them require the person to be taken directly to the nearest magistrate. When they get to that magistrate, under 2.11 Texas Code of Criminal Procedure, when a magistrate sits for the purpose of examining into a criminal accusation, that is an examining court. And what I suggest to people to better understand what's going on, get the penal code, read it. Don't try to understand it, just read it. Read through it. It's not as big as it appears because it's outlined. There's a lot of white space. And read about halfway through. When you get about halfway through, it gets into really esoteric stuff. But all that stuff we get charged with is between chapter 1 and chapter 40, maybe 42. When you get into the weird stuff, stop it. Go back and read it again. First time, don't try to understand it. Just read it. Because what you're doing is you're laying down mental markers. The second time you go through it, you read Article 2.10. It says that the magistrates, 2.09 says who are magistrates. It lists them all. 2.10 says the magistrate shall keep the peace in the state of Texas. 2.11 says the magistrate sits for the purpose of examining into a criminal accusation that's in examining court. Second time you read it, you'll say, that's what chapter 16 is about. When you go through that code the second time, you'll start making those connections back and forth. Then we can sit down and have a really intelligent conversation about the code. It's easier than you think. The police, prosecutors, and lawyers, they want you to think this is difficult. It's not so difficult. I get up here and I do these presentations, and you hear me spouting out these codes, and you think, oh, that guy's got the code memorized. No, I got about a half a dozen of them. They keep coming up over and over and over. The critical one, 39.03. It says that it mimics 18 U.S. Code 241, 242, specifically 242, the Ku Klux Klan Act. If a public official, acting under the color or pretense of his official capacity, exerts or purports to exert an authority he does not expressly have, or fails to perform a duty he's required to perform, and in the process denies citizens full free access to or enjoyment of the right. Anybody ever had that happen to them? That's a Class A misdemeanor in Texas. We just filed we got a ruling from the district court, and we asked for findings of fact and conclusions at law under Rule 297. In Texas, if you get a negative ruling and you don't ask for findings of fact, the courts can ruled that you waive your objection. So we asked for findings of fact and conclusions of law. Well, the law said, 297 said, the judge shall produce findings of fact and conclusions of law within 20 days. It did not say may, might, can, if he wants to. It said shall. So it says that if he doesn't produce it within 20 days, you can file a motion for late filing, and he's got 10 more days. Well, on the 21st day, we filed a motion, a notice of late filing, and we filed criminal charges with the grand jury. Official oppression. I bet he didn't see that coming. My point is, you have so much remedy. I've looked at I've done these seminars all over the country, and I can tell you for certain, Texas has absolutely the best body of law of any state in the union. There is not a remedy I need that's not in that code. What I do, I take their code and I cram it up their behinds. I got all these rules. First rule, never ask a public official to do anything you actually want them to do. Because you never ask a public official to do anything that the law does not compel them to do. Then when they don't do it, boom, you get the land on them. We run what I call the routine on them. If I can get a public official to do something that exceeds their authority, these guys that go in and do First Amendment audits, they come in with their cameras, and the policeman comes over and says, "Can I help you?" "No, I'm good, beat it." You go back to photographing, he steps up again, "May I help you?" "Get lost." Now I feel threatened because he's got a pistol. Texas has a special statute about that pistol. That is really a big deal. I'll get to that in a second. The third time he steps up and says, "Can I help you?" I call 911. I got someone out here. He's interfering with me, and he appears to be agitated, and he's got a gun. Get someone out here to take my criminal complaint against him for a criminal violation 3903 Penal Code, in that he exerted or purported to exert authority he did not expressly have in the process, denied me full free access to enjoyment of right. Well, when the 911 guy gets out there, here's where we go to another rule. Never give legal advice. And that's a corollary to never give fair warning. "Oh, I got this right, I got that right, you're supposed to do this, you're supposed to..." No, that's not how we do that. Bushwhack. Bushwhack is so much better. Annoy him. The guy wants to have an attitude, help him. And as soon as you get the slightest indication that he is agitated, call 911. In Bonnie's case, I wrote a criminal complaint against her judge. And I took it, I put it in a folder, and on the front of it, it said, "Some magistrate." And I went into Judge Bosworth's court. But Judge Bosworth, he didn't know I was there. If he had, he'd have been more careful. He's dealt with me before. And I told the bailiff that I had business with the court. "Where's the judge?" "He's in his chambers. Give him this." He looked at it, and it said, "Some magistrate." "What is it?" "None of your business. Give it to the judge." He took it back. Well, once the judge touched it, he stuck to it. Well, the bailiff brought it back and said, "The judge said he won't accept anything that doesn't have a case number on it." I said, "He will accept this. I have invoked his duty as a magistrate, and that's a duty from which he may not shield himself." "Well, he's not going to take it." And he threw it down on the floor. I took out my cell phone, and I'm in the foyer to the court. He said, "You can't use that cell phone in here." And I held it down where he could see it, 911. He split. So my cell phone wouldn't get out. Darn. So I went outside, and these two bailiffs at the metal detector are yakking back and forth. And I said, "Hi guys, how are things going?" And they said, "Oh, it's going pretty good." Well, it's about to go downhill. Well, they got tense. Well, what can I do for you? You can call 911, get an officer out here, a sheriff's deputy out here to arrest Judge Bosworth. Well, that backed him up a step or two. I bet they hadn't had that happen before. Guys, the first time you do that, you will be hooked. I'm telling you, I do this stuff, and there's one really big problem with it. And I warn people about it on my radio show all the time. This can get addictive. This is way too much fun. Because when the 911 guy gets there, you get to see what we call this little chicken dance. Mr. Kelton, I can't arrest him. I said, sure you can. Just throw the cuffs on him and drag him off to jail. Hey, you ain't got far to go. You got one down in the basement. Oh, no, Mr. Kelton. I can't arrest him. I said, officer, I need you to take your chicken suit off. And I always say that. The reason I say that is because what the police want to do is they want to accuse you of being agitated. Once they accuse you of being agitated, everybody just kind of loads up against you. So you want to short circuit that real quick. I had one in Garland. The bailiff, I told him to arrest the judge. I'm not going to arrest the judge. Mr. Bailiff, I need you to take your chicken suit off. He was walking back to the courtroom when I said that. He stopped, turned around real slow. Did you just call me a coward? Yes, matter of fact, I did. You're a stinking, frightened coward. Get that chicken suit off, and get in there and arrest that judge. I'm not going to arrest the judge. Well, life is filled with little decisions. We all get to make some. Your turn. It's your duty to keep the peace in the courtroom. It makes no difference who breaches it. Are you going to refuse to perform your duty and shield that judge from prosecution in violation of 3805 Penal Code? Now it's a felony in Texas. Your call. Decide. Well, I'm not going to arrest the judge. Okay, don't go anywhere. Somebody's going to want to talk to you. Zip. 911. Once you start doing this, you walk down to the courthouse. If you listen real close, you can hear every anal sphincter in the building shut. Now, I never try to get anybody indicted. I try to get reasons to file criminal charges against them with the grand jury, but I never want to indict them. In this case, it was a circus. These two bailiffs, they got their sergeant, and their sergeant came up. The sergeant was good. I seldom get a sergeant this good. Female. Maybe that's why they keep the cool better. And I told her, she said, what can I do for you? I need you to arrest Judge Bosworth. She said that we're bailiffs, we don't do that. I said, are you a certified peace officer in the state of Texas? She said, yes, I am. Then you do that. And she kind of cringed and backed up a little. Well, what did he do? Denied me full free access to or enjoyment of right. Well, he violated 3903 Penal Code in that he failed to perform a duty he ascribed to perform. This process denied me full and free access to or enjoyment of right. She said, don't give me all those statutes. All I deal in are the elements. I leaned over her. She was short. I just gave you the elements. I'm doing everything I can to push her over the edge. But she was smarter than most. She knew exactly what I was doing. She wasn't going over the edge. I finally got her to go give me a voluntary statement. And all these bailiffs are standing around watching this. I just ground her real good in front of her bailiffs. And I turned around and looked at these guys and I said, you know, she handled me really well. And I like to be handled really well. You could learn from her. Once you've done this a time or two, this part gets easy. If you want to affect change in Texas, this is how we do it. I've been doing this for a long time, but I'm just one guy. You go to Austin. I was in the last case I had in Austin. They appointed me counsel. I'll get to how to handle counsel. Oh, you guys going to court without counsel? We got to fix that. Go ahead, get counsel. I'll show you how to kick your lawyers behind every way from Sunday. Going to court is like sitting down at a four-sided chessboard. It's all about relationships. You sit down at your table, your lawyer's to your right, opposing counsel to your left, the judge across from you. You have a relationship with your lawyer. Your lawyer has a relationship with opposing counsel and the judge. Both of them have a relationship with the judge. You're the odd one out. The way to win your case is to get inside these relationships. I just had someone who was, their lawyer wasn't acting in their benefit, so I had him bar grieve the prosecutor. Bar grievances. Do you know what happens if you file a bar grievance against a lawyer in the state of Texas? The state bar will get that grievance and they will throw it in the trash. And that's a good thing. The reason it's a good thing is all these lawyers have insurance carriers. And those insurance carriers have an agent. And it is that agent's job to charge his client as much as possible and avoid any claims. There are 9 carriers of legal errors and omissions policies in the country, underwriters, and they're all underwritten by Lloyd's of London. They all have the same rules. 1 bar grievance, your first year of practice, they cancel immediately. 2 bar grievances in your 1 year of practice, they cancel. 3, they cancel your law firm's malpractice insurance. Valid, invalid, they don't care. You buy a new car, you get insurance on it. You go down to Walmart, you go inside, come out, somebody's backed into it, bashed a fender in. You call your insurance company, they come out and fix it, you increase your rates. You go down there next month, somebody bashes in another one. They come out and fix it, cancel. Your fault, their fault, nobody's fault. They don't care. You are an unacceptable risk. Lawyers are in the same place. My co-host is helping a woman in a foreclosure issue. And they're doing everything wrong. So every time they send him a letter, he bar grieves them. They send him a second letter, he bar grieves the whole law firm. He's on the 10th law firm. They disappear quickly. You got someone who thinks he has things under control, you start bar grieving his lawyer. Each lawyer he hires is going to know what happened to the first one, and their costs are going to go up. Which goes to another issue. You can never expect to win your case simply because you have the law and the facts on your side. To think so is naive. It is not that way now. Never has been that way, so long as we've had human beings as judges. You can expect to win your case if you have the politics on your side, and all politics is local. Now at first, that sounds horrible. But it's only horrible if you don't understand that's how it is. Now, I'm the law guy. I do everything right by code. But I understand code's not going to win me the day. What's going to win me the day is the fact that I am the master of the servant. And I can kick their behinds every way from Sunday. I can ruin every professional in the place. And there is absolutely nothing they can do about it. If you file a bar grievance against a lawyer and somebody else asks you why you did that, we file bar grievance against him for that. Because he's forbidden to tell anybody about it. So it's like you go into court and you both stand behind your tables and before court starts you go over your opposing counsel and you kick him right square in his professional behind. And he's got to stand there and act like he didn't do it. So guys, you want to fight? I will give you a romp through the legal system you will not believe. I will cheat. I'll use every stinking low-down trick I can find because I learned it from you guys. The Republic of Texas, I gave a presentation to the Republic 7 or 8 years ago. If I can get the Republic of Texas to understand how powerful each one of you are, you guys can change everything. Go into any court in Tarrant County and mention my name. If you listen real close, you can hear their anal sphincter muscle pucker up. And what got this mostly was I was just screwing around one day. You gotta have some water. I'll get you some. I was just screwing around. Judge Hayes is a real nasty character, real mean-spirited judge. He was the JP of Mansfield. We're helping people stop foreclosures. And David was in front of me. Foreclosure, you can represent someone, not be a lawyer. That's the only thing you can do that for. So David goes up first, and I walked up and stood at the bar and just stood there. Finally, Judge Hayes looked up and said, "Can I help you?" I said, "Yes, Your Honor. My name's Randy Kelton, and I have a hearing deficiency." "Well, Mr. Kelton, what's wrong with your hearing?" "Oh, Judge, I was down in Mexico the other day, and I drank too much of that cheap tequila, and I lost my hearing aid." "Well, why are you telling me this?" I said, "Do you have accommodation for the hearing impaired?" "No, I do not." "You got a sound system here where you turn it up." "No, I will not." "Well, then will you speak up?" And he did. Told the bailiff, if I didn't sound shut up, he's going to throw me out of the courtroom. So I sat down. They ruled against David. They called me up. Now the judge, when I walked through the door, already knew who I was. I'd hammered him a time or two. So he should have knew better. And he started the hearing. "Objection. I am here at arm's length to the court. I have a challenge to subject matter jurisdiction before the court." "Yes, Mr. Kelton, you just filed that 20 minutes ago." "Yes, Your Honor. As a matter of fact, I did." "Well, I'm going to deny that." You can't deny a subject matter jurisdiction challenge. Period. You just can't deny one. If I say, "I challenge your jurisdiction is gone. When you go into court, jurisdiction is assumed. And if it's not challenged, then you move ahead. If anybody challenges it, and they don't have to challenge it with cause, if they just say, "I challenge your jurisdiction," his jurisdiction is gone until he proves it, not opposing side. Now, he can get opposing side to do it for him, but he's the one that has to show he has jurisdiction before he orders you to do anything. He has to make sure that he can. So he denied it. I said, "So you're going to deny that without even reading it?" "You have my ruling." "Yes, I do." I slammed my folder shut and stood up and said, "We're done here." I pointed at the bailiff. "You, come with me." And I stormed out of the courtroom. I'm telling you guys this because you go into these courts, and everybody's afraid of this judge. Screw that judge. He's got two jobs. Determine the facts in accordance with the rules of evidence, apply the law as it comes to him with the facts in the case. If he wants to try something else, we're going to dance. It ain't going to work out so good for him. So understand that. So I storm out of the courtroom. This big old bailiff follows me out. He said, "Thank you, thank you." He said, "Well, what can I do for you, Mr. Kelton?" I said, "You could arrest the judge." "Well, why would I arrest the judge?" "Class A misdemeanor official oppression, criminal violation 3903 Penal Code, in that he failed to perform a duty he is required to perform, and in the process denied me full free access to or enjoyment of a right." "Well, Mr. Kelton, what right did he deny you in?" "He denied me my right to accommodation under the Americans with Disabilities Act."
Hey, Randy, you need one break with last thing. Bruce him up with this keyboard. Sorry. We got like 8 and 9. We get that's good.
I sent Brian the form. So if you have access to it, and I'll send you a Word file that has the text of the form you have to fill out by hand. And then there's a Word file that I print over top of the form at the end, which is basically text of the complaints. Jurisprudence.website. Actually, it's ruleoflawrings.com.
Is that your website? Kelton?
That's one of them.
Okay.
All one word. Rule of law rings.
Yes.
Oh, small.
All one word.
Email address.
So there's no spaces. So you think that would shut this case down? It'll definitely put a damper on it. Don't you need a cause? I mean, I'm grieving this because Randy probably testified how he bargained with the lawyer for partners here on the left. Oh, that's funny. But if I help you piece it up, you'll have a bunch of dollars for me.
Well, nothing better than to put this in my rear view mirror.
Yeah, well, we need to help you do that.
Mm-hmm. That attorney left me sitting in the lurch. Didn't feel like going. I mean, I was dizzy. I had a hard time with it because of that.
Oh, I just kicked you. You had this?
Yep.
Okay, sorry.
Yeah, I did the same thing earlier when I was sitting there.
Oh,
That's why you moved.
Yeah, he left me hanging out in the breeze after I gave him a letter from my cardiologist. Your doctor saying that there's no high pressure situation that you can get a heart call or a stroke? Yeah, pretty much. And so he needs me to sit there and get around.
This is the county.
okay. Back where we were. The point of this story is, you go in there and jerk around the judge if you want to. He's got limits in what he can do. So the bailiff asked me why I wanted to arrest the judge, and I told him he denied me my right to accommodation under the Americans with Disabilities Act. And the bailiff said, well, why didn't you tell the judge about the Americans with Disabilities Act? Well, hell, if I'd done that, he might have turned the sound up. The bailiff stood there a minute, and this grin come across his face. You set him up. Yeah, he's a sucker for that one. This bailiff is huge. He said, he was a sucker for that one. Now get in there and arrest him. I can't arrest the judge. Sure you can. Look at you. Big strapping officer. Got that pistol on your hip. You need to take your chicken suit off. I ain't taking my chicken suit off. I saw him 2 days later in a political rally. He taught me a valuable lesson. I was wandering around the pavilion, and I saw him when I came in. I thought he looked familiar, but I didn't recognize him. And he said, Mr. Kelton, I got some people I would like you to meet. He said, they're bailiffs for the county, and we do these gigs here so we make some extra money. And he took me to this room and opened the door, and I knew 2 or 3 of the bailiffs already, because I'd hammered them in the past. These bailiffs come over and shook my hand, and the vitriol that come out of their mouths about those judges, I was astounded. They hate those judges. They stand there every day and watch the judge screw one person after another. And they know, they see this person, and they know exactly what that person should say or do. They got to stand there mute while the judge is screwing them around. I was surprised. It changed my perspective on bailiffs. I've had my perspective completely changed on public officials altogether. I no longer consider public officials bad guys. They're the problem out here, but they're not the problem. I'm an engineer. If you bring me a system, and the system is failing universally, I'm not going to blame the operator. I'm going to look at that system and think, there is something key that's disrupting this whole system. It's unreasonable to think the whole system will go bad all at once. There is something underneath. I spent 30 years looking for what was the problem with this system, and I found it. It's him. And it's him, and it's you, and it's me. We are the problem. The first time one of our officials stepped half-inch across the legal line, we didn't raise up and rail in righteous indignation. We didn't make darn well sure. No, I think of my public officials like my grandkids. I love them dearly. But if one of them runs out the road, I'm fixing to pound his eye. I never want anybody indicted. It's much more powerful to have them look at the prospect of being indicted. You remember that. Came and got me with Costa. Had a kid in jail in Conroe. When was this?
It was 10 years, I guess.
A long time ago. Oh, 2008. I just had looked that up the other day because of what happened as a result of this. Now, I made up this habeas corpus. We took it down to Conroe, and I took it to the clerk and told the clerk, are you going to give this to the judge, or do I need to do that myself? So I'm telling the judge that I know what this is. This is the habeas. This is the great writ. Everything stands down before the writ. I said, don't try to screw me around here. She said, well, I will give it to the judge. You can go sit in the courtroom. Well, they're having a murder trial, and they're interviewing a witness. They get finished. They send the jury out. They take the accused out, and he tells everybody else, you can go or stay, whatever you want to. We have something to deal with. And then he said, are you Randall Kelton? Yes, Your Honor, I am. Did you file this habeas? Yes, Your Honor, I did. He said, are you an attorney? Oh, no, Judge. I sleep well at night and keep my hands in my own pockets. Thank you very much. Well, he didn't see humor in that. And he said, well, Mr. Kelton, since you're not an attorney, I'm not going to accept this habeas. I turned to the bailiff. Mr. Bailiff, did you hear that? Yes, Mr. Kelton, I did. Arrest that judge. Now, I could have told the judge, well, Your Honor, you see, 11.151 says the habeas may be filed by the accused counsel, or any other person. I could have told him that. But bushwhack is so much better. So I told the bailiff, arrest that judge. Well, I can't arrest the judge. I sure can. Just go over and drag him off the bench and drag him downstairs. You got one right in the basement. You don't have far to go. And we had this argument back and forth. I pulled a take the chicken soup routine off of him, the whole deal. Life's filled with little decisions. We all get to make some. You want to arrest that judge in accordance with your duty under Article 2.13 Code of Criminal Procedure? Or are you going to shield that judge from prosecution in violation of 3805 Penal Code? Your call. That was a felony. When he absolutely refused, the judge picked up the gavel. And he said, Mr. Bailiff, if Mr. Kelton doesn't leave my courtroom, you're to arrest him. I said, Your Honor, with all due respect, that's cheating. He held up the gavel and rolled it around, and he said, maybe. But I got the gavel. Yeah, good point. You, come with me. I stormed out of the courtroom. That was so much fun. And then I took that habeas, because I'm trying to get this kid out of jail. So I took it to the Texas Court of Criminal Appeals, highest criminal court in Texas. And the clerk said, I can't accept this without a motion for leave to file. I said, are you kidding me? This is a habeas, the great writ, the writ of right. This court has no power to grant or deny leave. You know, the Court of Criminal Appeals in Texas, for the last 30 years, had been requiring a motion for leave to file, and if you were pro se, they denied you leave. Every lawyer in Texas knew they were doing this. And not one of them made a peep, because they couldn't. They didn't dare do anything to upset those judges. And we'll get to the weakness of lawyers in a bit. So I told him, this is a great writ. They have no power to grant or deny. Well, I got to have it in order to take this fight. Well, I got this kid in jail. Not my fight. I'm trying to get him out. So I make up a motion for leave to file. I, Randall Kelton, hereby move the court to grant me leave to file habeas, and sign the file. They denied it immediately. Say what? You deny a habeas? Are you out of your mind? Went straight to the grand jury. Made up a 119-page complaint. Move this up a little. You'll find it right there.
Real habeas corpus?
That's the habeas I filed for. What was the kid's name?
Carl.
Carl. Okay.
Danny Schultz, wasn't
Schultz. Danny Schultz.
Yeah.
German name. Okay. So I filed this with the Court of Criminal Appeals. They denied it. I went to the grand jury, made up a 119-page criminal complaint against them. The district attorney, when I went to the grand jury, I had a camera crew with me, big stick. The assistant DA came in and said that I couldn't file that with the grand jury. Is that a fact? She said, that's a fact. Don't go anywhere. I'll be back tomorrow. I came back the next day with criminal complaints against her, Claire Austin Brown, for obstruction. That's how we do this. Never ask a public official to do anything you actually want them to do. That's when they don't, boom, you get them. I wound up bushwhacking the head criminal district judge in Travis County in his courtroom. There's a trick to this. You want to find a time when the judge is holding motion hearings. Because these lawyers, they all file these same motions. And they were lined up in front of the judge. He's just going through 30 seconds at least, because they're standard stuff. And I walk in, and they're having a hearing right at the bench, because there's so many of them, it's going so quickly. And I walk in, I've got a nice suit on, and I got a red folder. Red folders matter. They can't help themselves. You gotta know what's in it. So I pointed to Bailey, you, come here. Now, he's used to lawyers coming in there like meek little lambs, because they're terrified of the courts. He's not used to being ordered around. So he come over, can I help you? Yes, you can. My name is Randall Kelton. I always tell him my name first, because I don't want any questions. My name is Randall Kelton. Instruct the judge that I have business with the court. They always say the same thing. May I tell him the nature of the business? There's two things to do with that. Either give him the folder, which I wasn't inclined to at that point, or tell him, no, you may not. I have business with the court, and it's none of yours. You're dismissed. I was really PO'd. And that worked. He was pretty PO'd. He stood there just shaking for a minute. I went, go. So I go sit down. Well, what's he going to do? He's a bailiff. It's not his court. So I go sit down. The judge, the bailiff ran up to the judge, jibber, 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 jibber. And the judge looked out at me, jibber, 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 jibber. And I'm holding this red folder. And the judge just can't help himself. He's got to know what's in it. So he finishes his hearing and he said, are you Randall Kelton? Yes, Your Honor, I am. I understand you have business with the court. Yes, Your Honor, I do. I held up this folder and said, may I approach? In court parlance, what that means is, can I give you this folder? He said, well, come on up. His name was Bob Perkins. Genuinely a nice guy. Very pleasant, very upbeat. I walk up, I hand him the folder. He He opens it, he's looking at criminal complaints, charges against the district attorney, accusing the district attorney of shielding criminal complaints against the highest judges in Texas from the grand jury. And I could see it in his eyes. He saw his whole career pass. Well, Mr. Kelton, these are criminal complaints, yes, Your Honor. Matter of fact, they are. Well, Mr. Kelton, I'm a district judge, and district judges don't take criminal complaints in Travis County. I said, oh, that's okay, Judge. I'm not here to invoke your duty as a district judge. I'm here to invoke your duty as a magistrate, and that's a duty from which you may not shield yourself. And he looked down at the folder, and he looked over at the bailiff, and I know what he's thinking. If I have my bailiff shoot this guy, can I get away with it? Well, he wound up, we had a pretty interesting back and forth. And he wound up having me file him with the district clerk. And that wasn't exactly the way it was supposed to be done, but he got it done. A year later, my criminal complaints went before the grand jury. Now, I accused the Court of Appeals of denying me leave to file. That was kind of nitpicky. And it went before the grand jury. I learned a valuable lesson that day. How the heck did this manage to finally get before the grand jury? I told Claire Dawson Brown, I said, look, Claire, Article 2.03, Texas Code of Criminal Procedure. 2.01 says it shall be the primary duty of the prosecuting attorney not to secure conviction, but to ensure that justice is served. He shall not seek witnesses or evidence that would tend to show the innocence of the accused or mitigate the guilt of the accused. Well, that's nice high-minded rhetoric, but it doesn't tell him to do something specifically. 2.03, county prosecutors handle this stuff, district will handle this stuff. 2.03, Texas is the only state that has it. When a prosecuting attorney is made in known, and I'm paraphrasing here, it's a little long and convoluted, is made in known in any manner that a public official has violated a law relating to his office, he shall reduce the complaint to an information submitted to the grand jury. Zero discretion. Well, a prosecutor shouldn't be put in a position to prosecute somebody he knows he works with. The legislature understood that. So they took him off that dime. They just can't help themselves. They just always want to climb back up on that dime. But he didn't. So I'm wondering, the grand jury got my complaints on their first day in office. And it was April 1st. And I promised myself, I just wrote a document and mentioned that. And I said, it's hard, but I'm not going to make a joke about that. April 1st, they held it to the last day in office. It generally takes them about 15 or 20 minutes to do an indictment. Halfway through, I went to Claire and I said, Ms. Brown, what's the problem? What's taking so long? She said, Mr. Kelton, I made sure that every grand juror read your entire presentment. Say, what? That's 119 pages. My habeas was in there. She's not trying to get these judges off. She's trying to get them indicted. What the heck is going on here? Everything is political. You'll never win your case simply because you have the law and the facts on your side. Ron Earl, 25-year district attorney. He's a Democrat. He's retiring. All 9 of these judges are Republicans. He's trying to take them with him to dirty runs. Scoundrel, they will never be afraid of you. What they'll be afraid of is the political cannon fodder you'll create for one of their political enemies. And that's where your power really is. When you go after a jurisdiction, look around. Who's up for election? Who's already had difficulty? Who has a strong opponent running against them? I filed a 151-page criminal complaint against the governor for his executive orders. I accused him of sedition, depraved heart murder, depraved heart assault, about 30 allegations of official oppression, official misconduct. The main one was sedition. And I had him dead bad. Sedition is armed, it's not an armed revolt against the government, but an attempt to prevent the execution of a law or a war against the Constitution using weapons. Well, the governor is made the head of the state militia. Problem is, we don't have a state militia. So he needed one. So he co-opted the DPS and brought them in as his state militia. DPS are traffic cops. The administrative code that creates the Department of Public Safety, one section says, the Department of Public Safety shall not enforce the criminal laws except at the request of and under the direction of local law enforcement. The traffic cops. Local law enforcement enforces the penal code, they enforce the commercial transportation code. I don't have time to go in exactly how that happened, but they come up with a new transportation code, give it to the sheriff and say, here, enforce all these cool new laws we got. He said, screw you, I don't have the funds for that. If you want that enforced, either give me more money or figure something else out. So the states created state police to enforce these commercial laws. Truman did that. He was a road builder before he was elected. He was aghast that they're building roads for these high-powered 3,000-pound pieces of metal that are designed for horse and buggies. And he had the Corps of Engineers design the superhighways, and he had them put together a set of traffic laws for these guys. And it was only the commercial trucks, the big trucks, they were poorly built, they had crap brakes, drivers didn't know what they were doing, they slaughtered people and damaging the infrastructure. So they put together this set of laws. This just after World War II. We just fought a world war for our freedom. We loved our new cars. We were not going to tolerate a set of code restricting our access to our cars. So the only way they could get it is against the commercial drivers. That's how it came in. I won't go into the traffic issue, but where was I?
You were talking about politics.
No, politics. Anyway, back to Travis County. He was retiring after 25 years in office. He's trying to take these judges out with him. All of you, you're not going to be afraid of him. You're going to be afraid of the politics you create. I just fought against the governor. And in a state of 29 million people, one guy. Where is everybody? Everybody was complaining about those executive orders. Where is everybody? He should have had 1 million of them in there. So I took it down to the district attorney's office and I ran into a perfect storm. I've got a lame duck Democrat prosecutor who just lost the primary. She's out of here. She's a Democrat. She needs some way to make a name with the Democratic Party. I went to him and I told him I got you a present. Actually, I took it down there and the ADA come out, an assistant district attorney, and said, can I help you? I said, yes, I'm supposed to inform the grand jury that I have business with him. He said, well, let me explain to you how the grand jury works. Don't you explain to me anything. You take these complaints and you give them to the foreman of the grand jury and don't you dare open them. I'll be right back. Well, they sent out an investigator and she asked me what's going on. I said, I have a present for you, boss. I have a complaint against the governor and I don't want anybody interfering with it. And she told me, if you will, she said, may I show these to my boss? I said, yes, you can. Takes you back, come out, and she said, if you will sign this, I will verify it under my capacity as a peace officer of the state of Texas, and she will give it to the grand jury. And she didn't, her successor did. The week my complaints went to the grand jury, the The governor rescinded all of his executive orders. 20 states followed suit. Guys, there is no reason you one of you couldn't have done that. You have exactly the same power I do. That's, if I can convince you of that, everything changes. You become the controlling factor in this state. When you start going after these guys using their own rules, they run like rabbits. You walk into any courthouse in Texas and mention my name, listen real close, you can hear them pucker. After pulling that hearing aid trick on the judge, the word was, if that Kelton SOB comes in your office, watch out. He's trying to get you to do something so he can try to get you arrested. And that's true, I am. But don't split with me. I'm hoping to see every one of you like that. Okay. That's my point. This is, we kind of don't have a lot of time today, so now let's go to how to do it. Can you pull up one of my complaints?
Documents and research.
Documents and research. Go down to jurisdictions I have annoying. There's a lot of them in there. Or in that one, go to November arrest. That's the documents I just handed around.
November arrest?
Yeah. It'll be your body. Now exhibits. Okay. Up at the top is one of the ones that lists the complaints that there's any more of those.
Just Kelton one?
Yeah.
Yeah.
I think the second one of them says 7-9.
7-9.
Right at the top.
Oh, what's at the top? There's Abbott criminal complaint.
That'll work. No, that's not the right one. Okay, bring that one up. This one's a little too big to demonstrate well. But what I do when I do criminal complaints, first thing you do is write a timeline. The timeline is the most important document you'll ever create. Timeline is not a statement of facts. Each on a separate line, you put the date, this happened. Next date, this happened. Next date, this happened. Just put down everything that happened related to whatever your situation is. Once you have it done, go back in a couple of days and go through it again. You'll start remembering stuff that came in between. When you're involved in one of these issues, you tend to react and respond emotionally to what's going on. So what you'll do is you will move from one emotional high point to the next, to the next, to the next. You don't know all of the things to look for. And you tend to be distracted by the stress and emotion of the moment. By writing a timeline, no argument, no explanation, you tend to get around that emotional pressure. Write the timeline, go back in a couple days, go down it again. Once you've got everything you can come up with, you want to get somebody else to look at it. Preferably somebody that's got some knowledge. When I get a timeline, I go down it, and I see this, and I see this. Wait. There's got to be something in between here. When you tell a story of what happened to you, depending on the context, you will tell different things and you'll tell them in different orders. Some recent research on memory doesn't work the way you thought it did. You don't go in and read memory. You go in and take the memory out and re-experience the memory and put it back. That's why people have so much trouble getting facts out of place. Because they re-experience the memory from a different context and then stick it back in there. The original stuff's in there, still in there. But when you go back in, you find the latest one you addressed. So you build that timeline, and that helps you get back to what happened originally. I've been caught in court raising an argument out of sequence. That was really embarrassing. and they clobbered me big time over it. This helps you to organize everything. Once you have that timeline, then use the timeline to tell your story. When you look at a complaint, if you look at a lawsuit starts with plaintiff will show the court the following, kind of an introduction. This is what I'm going to talk about. And then it goes to a statement of facts. These are the facts of the case. And then it goes to points and authorities, where it takes the facts and stitches them together with law and shows how the law should be applied to the facts. And then it goes to claims and causes of action, reports and causes of action. Well, that's how they're set up, and then it goes to a conclusion and a prayer. But that's not how you do it. You make the timeline first. That won't go in the document. That's for you. Then you take that timeline and you turn it into your points and authorities. Now you tell the whole story. But you tell it in accordance with the timeline. Once you have the timeline completed, then once you have, the points and authority, you have your story, you tell your novel. Tell everything that happens. Doesn't matter if you think you're going to use it or not, put it all in there. We can take extra stuff out later, but we don't want to miss anything. Once we've got that, we've got the backbone for everything. Now we look at that and say, okay, what claims rise out of these facts? And then you create a section of claims, cause of action. So you put in the cause of action. The cause of action takes a little different set of facts and elements than the claim will in your points and authorities. A cause of action, a criminal complaint is a cause of action. That's specific to criminal. In civil, there are torts and causes of action. Causes of action are defined. Fraud by non-disclosure. It's got a set of elements. There's a book floating around, causes of action. Anytime you're going to make a complaint, get one of these books. These are litigation guides. You don't really think lawyers know all this stuff, do you? They don't know squat.
I got a good secretary.
Lawyers go to college and they're taught how to argue legal issues. They don't learn how to practice law. Once they get out, they all want to get picked up by a law firm, and the lawyers teach them how things actually work out here in the real world. And one of the first things they find out is, don't write those pleadings, you crazy? Get the litigation guide. Everybody uses the litigation guide so that when the judge sees the pleading, he will see everything in exactly the place he expects to see it. All of the basic law is already in there. Everybody uses exactly the same law. So he don't have to mess with it. He recognizes it. He's seen this 100 times. A friend of mine's in a foreclosure issue. He's my civil go-to guy, civil strategy. But he didn't know foreclosure. He came to me, he wrote a motion for restraining order. He sent it to me, he said, what do you think? It's a piece of crap, Ted. He said, think you can do better? All right. So I sent him one. He took it to court, gave it to the judge. The lawyers showed up. They didn't expect the lawyer to show up, but he did. They went in, the court gave him his restraining order, came out, and the lawyer said, they give the new lawyers the pro ses for practice. That's the reason they have it. He said to Ken, did you write? I said, are you an attorney? He said, no, but my brother is. Did you write this? He said, yes, but I had some help. He said, this is really good. And Ken told me that. And I thought, what the hell? I took O'Connor's forms and filled in the blanks. And I thought about that. Why would he say that? He's a new lawyer. And he saw that restraining order and said, oh my goodness, that looks just like ours. He didn't realize they all use the litigation guide. If you don't, if you write up your own pleading, do all your own research, you give that to the judge and it's got 15 or 20 cases he's never seen before, what do you think he's going to do? Read all those cases and study all of them? Denied, denied. Now that may not be right. That's how it works in the world we all live in. So get the litigation guide. I never write a document without my litigation guide right in front of me. My complaints here do not miss one single element. And every single element has got all the case law that it needs to support it. 90% of this document, I didn't write it. I have one skill that I have honed beyond all others. I am an accomplished plagiarist. If you're writing a document and you're not dropping in pieces of case law and then crafting intros and outros, changing the case so it reads right, you haven't done enough research. And the way to do the research is the litigation guide. Now, I don't like to use the cases that are in the litigation guide. I got this little trick I use. I pull up the case that it cites, and I don't read the whole case, just the section that it refers to. And it will refer to some other cases. So I will take that section and drop it in my document. I won't cite that case. I'll cite the cases it cites. The judge will read it, and he will know exactly what I've done. And that will give your document much more credibility because he knows you didn't write it. This was written by a judge. When you start reading case law, frankly, I find case law just incredibly interesting. I'm a student of writing. My library used to take up 8 feet across my wall on how to write law. I read these court opinions and I'm amazed at how well they write. When you start plagiarizing these judges, you'll get other judges who will really pay attention to your documents. 90% of your work's already done for you. This is not near as hard as it appears. So you write out your points and authorities. You go down the litigation guide to each issue, each element, each criminal complaint you're going to allege. You call up the complaint and it'll tell you how to write it and what all the elements of that charge are. If you miss one of them, you won't have a claim. Same thing with causes of action. See, fraud by non-disclosure. The party must have made a voluntary statement. The party must have failed to disclose. The party made a voluntary disclosure and failed to disclose a piece of information. The party must have reason to believe that you don't have access to that information. You must accept and believe the statement of the party, and you must be harmed by it thereby. You have to argue each one of those. You miss one, the court has no power to rule in your favor. You can go into the court with the most elegant stories and the most convincing arguments, but if you don't give the judge facts and law, you cannot rule in your favor. The judge has two duties: determine the facts in accordance with the rules of evidence, apply the law as it comes to him to the facts of the case. And this goes to another really important thing to understand. You should never expect to win your case in the trial court. No lawyer expects to win his case in the trial court. He doesn't care. When you write a document, you write it for the Court of Appeals. And the Court of Appeals, the only thing they can look at, facts and law. Now, the trial judge doesn't care so much about that because his rulings don't become law. So he's generally trying to find an equitable ruling between the two parties. A good, honest judge, that's what they do. When you appeal it, and the Court of Appeal gets it, what they rule, every other lawyer in the country, in the state, can use as fixed law. So if they render a screwed up ruling, every other lawyer can use that. And it will disrupt the corpus juris, the body of law. It's their job to protect it. So So they have a whole different perspective. When you go into court, and the only thing you're doing in the court, in the trial court, is setting the record, the judge and the lawyer on the other side will figure that out pretty quick. Because you can't do anything that annoys you. Can't do anything to cause you to feel betrayed. That's the tool they use against us. We go in there and we expect them to do their job, to be honest judges, to rule in our favor. Well, if you're a good judge, neither party is likely to be happy. I was talking to someone about family law. If you're a good family law judge, both parties are going to be upset at you. Deal with it. It's how it works. You go into court, in the trial court, you're not likely to be happy with what the judge does. Who cares? Your only purpose is to get facts and law on the record. When you do that, when the judge or the prosecutor, the lawyer on the other side starts pulling his shenanigans, first thing you do is bar grieve. I once bar grieved a lawyer because he parted his hair on the left. Well, he was furious. And after the case, "Hey, what'd you do that for?" I said, "Well, if I'd have grieved you for what you really did, they might have disbarred you." But it still put a mark on his record. So he just bar grieved the snot out of him. Every time the judge moves, you don't like it, file a judicial conduct complaint. If you have reason to believe that the judge failed to properly apply the law to the facts, Texas has a case that I've not seen anywhere else. It's Packer v. Walker. Oh, it's good. It says a judge has no discretion in properly applying the law to the facts. A failure to do so is an abuse of discretion. Well, I read that and said, well, if a public official abuses his discretion and in the process denies a citizen full and free access to or enjoyment of the right, the way I read 39.03 Penal Code, that's a Class A misdemeanor. And in the Fed, it's 18 U.S. Code 242. So we asked a judge for a findings of fact and conclusions at law, and he didn't get it in 20 days. Boom! We gave it a criminal complaint to the grand jury. The prosecutor is a good friend of mine. He said when the judge found out about that, he was so furious. Greg was afraid he was going to have a heart attack. Well, the grand jury's not going to indict the judge. Who cares? I didn't want the judge indicted. I wanted to get his attention. And I got it. Mm-hmm. We could get rid of all of our public officials, replace them all, we do something else. Let's take our public officials and sting them really good. You know, before you start doing anything, define your intended outcome. If you don't know where you're going, there's a very good chance you're going to wind up somewhere else. Bailiff, Mr. Bailiff, take that man's phone. So always know what you want. At the end of the day, what for you would be a win. Because if you don't have that, you need it written down. Because you get in the heat of these things and they push you, they prod you, they annoy you. They will do everything they can to lead you down a rabbit hole. But if you have your goal written up there, write it down physically. Keep your eye on it. It will keep them from being able to lead you astray. Whenever I get into one of these battles, it is never a problem finding criminal complaints filed against public officials. They will give you more than you can possibly get to. I mark them all down. And then I look at my intended outcome, and then I look at my story I'm telling, and I say, okay, how can I stitch these complaints into my story so that they follow one from the other? You see, you do the causes, the points and authorities, you do the causes of action. Then you go back into a statement of facts. A statement of facts is an art form. You write your introduction. Your Honor, this is what I'm going to tell you. This is what I'm going to prove. So you've told the judge or the jury how to read your statement of facts. So they're going to read your statement of facts in a way that makes sense and leads to the claim you told them you're going to make. So you don't tell them all the facts. You line those facts that when a reasonable person of ordinary prudence reads them, they would tend to stitch things together and come to the conclusion you want to come to. Then when they read your points and authorities and you come to those conclusions, now they may not agree with you. They may not necessarily rule in your favor, but if you have came to the same conclusions that you got them to come to in your statement of facts, you're going to get a lot more credibility from the judge. A lot more likely to win the case. Every single document you do this way. And when you start producing documents for the court, each step through building this leads to the next step. And then you file your suit, and the judge rules against you. So you file a motion for request for findings of fact and conclusions of law. You include in that your own findings of fact and conclusions of law. You tell the judge to take your original suit, and I made these claims, I propose these laws. These laws should apply, I stated these facts, and these laws, the laws should apply to the facts this way. And then you ask the judge to either accept your findings of fact and conclusions of law or prepare his own. Whether he accepts yours or not, they're in the record. And what you've just done is created half of your appellate document. You created your findings of fact and conclusions from your lawsuit. That did most of it. You just add a little law to the claims in the suit, and you've got your findings of fact. When the judge denies that, you take the findings of fact, add a little more to it, you've got your appeal. Every step leads to the next. This gets to be a habit. It is very easy to produce these. Now I'm going to go to criminal complaints specifically. Almost always you have a whole bunch of criminal complaints. You very seldom ever find one in isolation. So you write up a story about all of the things that happen. But when you're writing the story, you have in mind that you're illuminating one criminal act after another. So you write it where you say, on or before this date, the defendant did this, that, or the other. Then when you create a criminal complaint, the criminal complaint in Texas has a special heading. It says it must run in the name of the state of Texas. So the complaint starts with, in the name and on the authority of the state of Texas, every one of them does. Then there's a paragraph that has to be on all of them. I've got a whole bunch of examples in there, stack of them. It has a paragraph that says, I, Randall Kelton, have reason to believe and do believe based on the following. That is a required sentence. In order to make a criminal accusation, you do not have to have personal knowledge. You merely have to have reason to believe and do believe. So that's my first paragraph, based on the following. And then the next section is shrunk, one font size, maybe two. I shrink the borders on each side, and I lower the line spacing so it stands out from all the rest. You go to your statement, capture that section out, drop it in the criminal complaint. And then you put the bottom paragraph. Based on the above, certain person on or before this, the making and filing of this complaint on this day committed the act of, name the act, in violation of, you put the penal code citation, and then sign it. The top and bottom is always the same. You go to your statement that you wrote, grab the section that defines this complaint out, and drop it in the complaint. If 2 or 3 people were involved in it, you drop it into 2 or 3 different complaints, just name, say you got 3 cops here to do that. Use one for each cop. That way, the grand jury's gonna read your statement. And then they're gonna go back and they're gonna read your complaint. And your complaint is gonna reiterate exactly what was in the statement. So it tells the grand jury exactly where this occurred in the overall scheme of things. In this particular one, not this one, the lawsuit I just filed, where they arrested me and held me there overnight, I got 50 criminal complaints. And those criminal complaints have sections of my statement of facts in it. Every one of the complaints comes directly out of the statement of facts. It makes creating a criminal complaint much, much easier. Every step leads directly to the next. That's basically how to do it. Once you start writing, if you have questions, call me. There's not much to it. There's only one thing that renders a criminal complaint absolutely void. You get the date wrong. If I accuse someone of doing something tomorrow, it's a critical flaw. It goes in the trash. So that's the only thing that makes one necessarily void. Criminal complaints are intended to be filed by ordinary people. So they're not expected to be perfect. When a prosecutor receives a complaint, he is to produce an information. If you want to know how a complaint should look, go into any criminal file and pull out the information. The officer writes a complaint. The officer takes that complaint and converts it into an information. An information is a criminal complaint in proper form. You take information off the top, the complaint in its place, you got a criminal complaint. The lawyers, the prosecutors will show you exactly how to write it. The rest of it is strategy. How do you want to use this? Who do you want involved? And that will go to the intended outcome. When I have a complaint, the first thing I want to do is take it to a magistrate. Nothing in law directs a criminal complaint to a prosecutor or police officer. Everything in law directs a criminal complaint to some magistrate. 2.13 Texas Code of Criminal Procedure tells the peace officer when he should keep the peace in the state of Texas, and when he has made known to him that a crime's been committed, he shall give notice to some magistrate. Everything directs a complaint to a magistrate. When the magistrate gets the complaint, he's required to hold an examining trial. And this is where the magic is. You have any of you have criminal complaints against you? Have any of you ever had criminal complaints against you? You want to make them go away? That document there,
That you gave to Frank?
the subject matter jurisdiction challenge. When a person is arrested, the 1406, 1516, 1406 without a warrant, 1516 with a warrant, the officer is required to take them directly to the nearest magistrate. The magistrate is to hold an examining trial under Chapter 16. It's a whole bunch of rights they have to provide the accused. Then, after the hearing, the magistrate shall issue an order stating whether he found probable cause, or released the person at liberty, bound them to the court, released them on bail, or remanded them to jail. He shall forward the order to the clerk of the court of jurisdiction. If an order is not filed in the court within 48 hours, the accused has a right to discharge. That's pretty clear. I defy any of you to look in the court record and find a 16.17 order.
Does that apply after an indictment's been issued?
I'll get to that in a second. Okay. There must be an examining trial, and the the magistrate must issue an order under 16.17. And then 17.30, the next chapter, says that after an examining trial, the magistrate shall seal all documents having a hearing. The order, the complaint, the statement of witnesses, and all other documents having a hearing in an envelope, cause his name to be written across the seal of the envelope and forwarded to the clerk of the court of jurisdiction. Now, by that statute, that's how it gets to the court of jurisdiction. It must be there. If there's not one there, I ask my clerk, you don't have a criminal complaint in the court record. You don't have an order from the magistrate under 16.17. How on earth did you create a cause number? Well, this is just how we do it. Yeah, I know how you do it. But how did you do it legally? They have no clue. There are a couple of counties that actually put an order in. Travis County is one of them. I think Bear County is another one. But their orders are based on magistration. Magistration is a bunch of crap. Magistration can only occur if someone's been arrested outside the county where the offense occurred. Say a policeman sees a guy commit a crime, the guy takes off while the cops are busy and can't find him. He locates him in another county. He has to take him to the nearest magistrate, and that magistrate can hold an examining trial, but since all the witnesses will be in the other county, he can do a magistration and just read him the rights. And then when they get him back to the county of jurisdiction, he has a right to an examining trial in the county of jurisdiction. But they're doing this for everything. You get arrested, they take you before a magistrate in the morning, he reads you your rights, and one of the rights he reads you have a right to an examining trial. While he's denying you one. And then that's all they do, then they tell you how much the bond is. They don't do all of these other things in Chapter 16. So there's never, a 1617 order never winds up in the record. And even if it does, it's based on the magistration, which denies you all the rights. There's about 7 or 8 different specific rights that are not there, so we can even challenge those. Grand juries. There actually is case law that says that a grand jury indictment takes the place of an examining trial. Horse manure does no such thing. Used to be 20.03, I'm sorry, 20.22. They changed the numbering to 2.03.303. I'm sorry, 2.03, I'm sorry, 220A.403. It tells the clerk that after the grand jury has voted, the foreman with a forum of the grand jury present, at least 9 members, shall read the fact of the true bill to the clerk or the court, and the clerk shall make notes in the minutes of the court, unless the person has not been arrested, in which case she must issue a capias and cannot enter notes in the minutes of the court until the person's been arrested. So what this brief says is the grand jury votes, they vote to true bill. The true bill stays at true. If the person has been arrested, they notify the court, then it becomes an indictment. If the person has not been arrested, it stays a true bill until the person's been arrested. But when the person's arrested, the law commands that he be taken directly to a magistrate. The magistrate's told an examining trial. This gives the this gives the accused the opportunity to enter exculpatory evidence in his own behalf.
Exculpatory?
Exculpatory.
Okay, got it.
Yeah, okay. Evidence that would tend to show the innocence of the accused. I filed a 150-page criminal complaint against the governor on the 8th. On the 9th, I filed that complaint with the Chief Justice of the Supreme. And I reasoned that since I was filing against the highest executive officer in the state of Texas, it's proper that I file with the highest level judicial officer in the state of Texas. 2.09 Texas Code of Criminal Procedure, who are magistrates. First one, justices of the Supreme Court. So I filed this complaint with Judge Hatch and invoked his duty as a magistrate, so that the governor would have opportunity to go before an examining trial and enter exculpatory evidence. As it was, he had to stand before a grand jury with only my complaint. It was ugly. So he refused to hold an examining trial. So I went to the presiding judge of the Court of Criminal Appeals. She was the same presiding judge that I put in front of a grand jury in 2008. Her name was Sharon Keller.
Oh, these aren't mine.
She'd already been there. She should have knew the problem. She spent 3 months in front of a grand jury wondering if her career was going to end. Nothing she could do. They got it on their first day. They no-billed on their last day. All 9 of those judges had to sit there and wonder if their career was going to end the next day. They had absolutely nothing they could do. And I brought that up to her. You should recognize this. The governor had a right to an opportunity to enter exculpatory evidence, and the Chief Justice denied him that right. I want him indicted. Well, the presiding judge refused to act. So I went back to the county I'm in, and I was demonstrating that this failure on the part of the system starts at the top and goes all the way to the bottom. And by going back to the county I live in, that gave me jurisdiction in Travis County, so I could drag all these guys from Wise County down to Travis County to get them tried. Played them like a fiddle. And they fell for it. They did everything exactly the way I expected them to. And all I expected was that they would refuse to do what they were required to do. At this point, I think I went through most of it, the basic stuff. Anybody have any questions?
Explain quickly the synopsis again, how you transferred that, you went into her county and showed a violation so that you could take it to your county of residence. How does that work again?
Oh, I live in Wise County. And, well, what happened, you can give notice to any magistrate in the state of Texas. Attorney General Opinion H500 says, any magistrate may hear any complaint, state or federal, felony or misdemeanor, from anywhere in the state. 2.10 says the magistrate shall keep the peace within the state of Texas. Doesn't say his jurisdiction. So any magistrate can hear any complaint. So I lived in Wise County, so I took it to the county judge in Wise County. And he refused to hold an examining trial. Surprise, surprise. And he's not in my suit, because I've had 2 judges I filed first-degree felony aggravated assault charges against. Both of them died. I gotta quit doing that. I really like this county judge. I hated to see him die. He was a really nice guy. He was the kind of judge I'd like to see. But anyway, I was just using him as a pawn in the process. And then I was back to file with the district judge against, they stopped me at the door for no mask. That wasn't my issue, but they were being annoying. So I asked the sergeant, I said, if I try to come in here without a mask, I see you're wearing a pistol. He said, yes, I am. I said, tell me, Mr. Stokes, is that pistol loaded? He said, yes, it is. So if I try to come in here without a mask, are you prepared to use that pistol? Yes, I am. That'll work. 911. That's first-degree felony aggravated assault in Texas. Only Texas has it. If you commit simple assault and you are prominently displaying a deadly weapon, that is a second-degree felony in Texas. Unless you are a public official acting under the color or pretense of an official capacity, in which case it is a felony of the first degree. When our legislators put pistols on these officers' hips in Texas, they put an incredibly serious responsibility on that. You want to play fast and loose with that pistol, Bubba? We'll see how that works out for you. So, I had complaints against him. I didn't care about him. This is just an excuse. And I told him I came up to see the district judge and he wasn't in the building. So I told him I'd be back tomorrow. I come back and they're waiting for me. And the bailiff downstairs asked me if I was prepared to use force. Force? How the hell would I do that? Well, you can do a citizen's arrest. Yeah, I could, but I don't need to. I got you. He asked me 3 times before we got to the second floor. And then I went to the door of the district judge's office, and another bailiff, Dick Woods, was standing there. I said, Dick, you need to get out of the way. So I go in that office and give that clerk these complaints. You're not going in that office. And I turned to the other sergeant, the other officer, Riggs. I said, well, Riggs, you're up. I need you to arrest Dick for official oppression and shielding from prosecution. I'm not going to arrest him, and you're not going in that office. I said, oh, wow, this is awkward. I would ask you to arrest yourself. I don't see that working out so good. I would ask Dick to arrest you because you didn't arrest Dick, but I don't see that working so good either. And behind me is the district attorney's office. We'll see what the district attorney has to say. I'm gone before they realize it. I'm in talking to the district attorney. They came in. They know I'm going to file criminal charges against them. And Riggs arrested me because he said I said, damn, and some bitch. There's a good chance I did. He told me, you can use that language in here, and I told him, you butt out. This is a private conversation. You sit over there and be quiet. Well, that kind of pushed him over the edge, and he arrested me. So that was the story. They let me out 26 hours. First thing I said, take me to the nearest magistrate. And it was ironic, because I was 30 feet from the magistrate I was coming to see. For that, I charged them a suit of $400 million. This is how I got to $400 million. In the state of Texas, anybody here know what the average conviction rate for all crimes across the board is?
About
100%.
99.6. This is the worst police state the world has ever seen. And I believe there's one reason. No examining trials. That's what caused this problem. I accused the prosecutor. Prosecutors were authorized to give legal advice to the police and lower courts. Our legislature, in their wisdom, decided that since we have learned counsel and public employee, we might as well have them give legal advice to the municipal courts, and JP courts, and the police. That was a really bad idea. You could expect that to lead directly to the disaster we have right now. They advise the police not to take them to a magistrate, take them straight to jail. If the person can't afford bond, then he leaves them in jail. And he'll get a hold of them every week or two and offer them a deal. And he'll hold them there till they take a deal. If they can't afford bond, then he calls them in once a month. They have to take a day off, or if they don't appear, they get thrown in jail. And they're always worried about winding up going to jail. So he holds this over them until they make a deal. I was in the court about 2 weeks ago, and a friend of mine wanted me to look in on this trial. And the prosecutor got up and spoke to the jury. They didn't have the jury in the jury box, they had them in the center for some reason. And they said, I'm sorry that things seem a little clunky around here, but this is the first criminal trial we've had since March of last year. Are you kidding me? 6,000 felony charges a year, one trial in a year and a half. The prosecutors got it going. Problem with that in 2017, the last year I had good numbers, the county courts paid $990 million for pre-trial incarceration. That's all these guys, the prosecutors leaving in jail so he don't have to prosecute the case. He forced him to take a deal. And I accused this prosecutor of deliberately leaving people in jail at $59 a day so he wouldn't have to adjudicate the cases. And he did this in conjunction with other lawyers around the state, and they're costing the county $990 million a year. So $400 million is not that unreasonable. What's debts, guys? You guys can do the same thing. There's nothing preventing me from doing what I'm doing. And all of you know public officials screwing up violating law.
What was the H500 that you mentioned?
Attorney General Opinion H500.
Okay, Attorney General opinion. Now, when you mentioned that we're going to statutory courts, so when
Anybody that wants to ask a question, would you please get a microphone? There are still people on Zoom that are trying to hear what's being said.
Okay.
Here's the word.
I need to sit down. I have a stupid injury. I was 21, invisible and invincible. Vietnam, standing on a Jeep, spotting incoming. We had backed it up to it. We had backed it up to a big dirt berm so that the Jeep engine would be in front of us. If we took incoming, we could get behind it. And we're spotting these things. Like one landed off to my right, and then one landed off to the left, and then one hit the ground in front of us. And I felt the hair on the back of my neck start to rise, and I'm thinking I should know something about this. And one went overhead. I turned to the guy next to me and I said, "Bracketing, bracketing!" And one went right between us. I looked down and the keys were smoking. So I turned to dive off the Jeep. The next one hit the front of the Jeep. The bonnet on the Jeep come off, hit me in the butt, drove me about 10 feet head first into the vet in the wall. But I didn't get a single trickle of blood. One scratch, and I'd get a Purple Heart and never have paper plates again. Instead, I got a purple tush. There is no justice, but it injured my hip. It took a while to go away. Now that I'm getting old, it's coming back. I told my wife that my butt hurt and asked her if she would kiss it and make it better. I've been 50 years trying to get her to do that. Okay.
when we are in your statutory courts as a defense, when we're in offense, do we come in and under common law?
No,
And
same courts, same statute.
okay, what about using case law before 1928 that they tell us we can't use?
They really don't pay any attention to any case law that's over 20 years old, unless it is an issue that is so well rooted in law that there's been no opportunity or reason to revisit it. Like there's one in particular that's out of 1811 that's cited often, but that's one that says that the legislature, unlike the Senate, the legislature, unlike the executive, the judiciary, unlike the legislature, may not ignore an issue because it's onerous. We must take jurisdiction where jurisdiction is had. We may not take jurisdiction where jurisdiction is not had. That's not something that ever changed, so we still use that same one. But they say that every 20 years all of the laws are revisited. So the only law that really carries any import is current law. And trying to use very old law, you have to make absolutely certain that that law hasn't been repealed or distinguished. Make sure you run, what is it you run on? Shepherds. You have to run Shepherds on it, make sure it hasn't changed. You use any law as long as it hasn't been changed.
I've had trouble
locating these motions hearings you're referring to? Motion hearing judge.
Wait a minute, I don't think your mic is working.
I've had trouble finding a motions hearing judge.
Okay,
How do you locate that? You contact the clerk and there should be a judge that,
Oh, no, when you file a motion, you file a cover letter with it for the clerks, for the judge's coordinator. And ask the coordinator to put this on for hearing. I generally like to call the coordinator. You want to get to know the court judge's coordinator. You call the coordinator and say, okay, when is the judge hearing motions next? Because they generally set a day to hear motions. And you want to get 2 dates. And ask her for 2 dates, and then you send to the other side a notice of motion and ask which date is better for you. They get to pick one or the other, and that's it. If they don't pick one or the other, then you just set one. And then when it comes up, they can't complain. They got notice. They could have gave you a different date and didn't. Everything in court is pretty well reasonable. These courts have been around for a long time. Our legal system grew out of the British legal system, and it started in the 12th century with the Magna Carta. So they had a long time. Any remedy you feel like you should have, I guarantee it's in there. And generally, the only thing I use for legal research is Google. I don't use Google Scholar. Google Scholar is a pain in the neck. I just use Google.
on the habeas corpus, do you still recommend the writ for motion to file, or
No.
shouldn't have to do that now?
Oh, they cut that crap out.
Okay.
That stopped immediately.
Okay.
Even before it went to the grand jury, that stopped. The only way it could get stopped is a pro se filing. This is our job. Lawyers, they go to law school, and they don't tell them in law school, you're going to spend the rest of your professional career kissing some arrogant judge's behind. If you expect your lawyer to go into court and actively adjudicate your case, if there's a risk that judge will be annoyed, you can forget that. I sued Denton County for $11 million. I talked to 60 lawyers. I kept a list of them. The last one I talked to, his name was Jerry Cobb. He was the prosecuting attorney prior to the one I was suing. I got a hold of him and I said, hello Jerry, my name's Randy Kelton, and I have sued Denton County and I need a lawyer to represent my case. He said, oh, Mr. Kelton, I know all about your case. I can't represent you. You made accusations against judges in there, and I have to represent clients in this county. I said, what's the matter, Jerry? You afraid those judges will screw your next client to get back at you? He said, you darn right they will. Now, I don't know if that's true or not, but I do know that every lawyer I talked to believed it was true. So when you get a lawyer, you got to understand where he lives. If you want your lawyer to be able to do a good job, you have to give him plausible deniability. It's not always nice. No, you don't have to bar grieve him. Bar grieve the one on the other side. My co-host was talking to a guy, and the guy's taking notes, and he mentioned bar grievance in passing. The guy put a note in the corner of the page. 2 days later, he was sitting in front of his attorney, talking to him, and the attorney saw that note on the corner of his page and freaked out. Filed a motion to withdraw. We had the kid object to the motion to withdraw. The lawyer went into court and accused him of filing a bar grievance, but he hadn't. He said, I can't do this. I can't work this way with a dagger to my throat and the sword of Damocles hanging over my head. That was really recorded. So he was terrified. So best first, you bar grieve the lawyer on the other side. And your lawyer's going to say, oh crap. You know, my last case, they dismissed my case to protect my lawyer from me. I was at the courthouse trying to get an apostille at the Secretary of State's office. And they refused to give you one, so I called 911. want somebody arrested, the clerk. Well, they decided to drag me out of there instead, and wouldn't let me leave. They wanted me to answer questions, and I refused. So I called 911 on them. And a sergeant showed up with about 20 other Capitol guards. They were DPS, but they were Capitol guards. And the sergeant come over. He said, Mr. Kelton, well, first I'm sitting here writing criminal complaints. This big black guy come over. Mr. Kelton, I need to ask you a question. I looked up, no questions. Keep writing. Mr. Kelton, I need to ask you some questions. Well, you can ask all you want. I'm not going to answer. Then he started to say something. I said, will you shut up? And he said, look, Mr. Kelton, I can ask all I want. You don't have to answer. I said, okay, you ask, I'll ignore. I went back to writing. And I have to give him credit. Real big guy. He handled it really well. It was clear to him that this was not going to work well. He didn't get stupid. Then his sergeant shows up. Mr. Kelton, I need to ask you some questions. No questions. Mr. Kelton, why don't you answer my questions? Because you're the bad guys. What do you mean we're the bad guys? I said, well, I call them good guys, the City of Austin Police, and they'll be here to take my criminal complaint against you and against these two guys, so it would be inappropriate for us to have any further communication. Well, he got ticked and ordered me out of the building. I can't leave the building. He said he'd arrest me if I leave the building. And the sergeant said, I'll arrest you if you don't. I went out on the porch, and he came back and tried to ask me questions again. And when I said, what part of I do not want to talk to you, do you not understand? He lost it. Grabbed me, smashed me into the wall, broke one of my teeth. They arrested me and put me in a patrol car. And this big black guy, it's his car. He came over and sat down in the car. And he's looking down, he's not looking at me. Clearly, he was mortified. I had really given him a hard time, and he maintained his composure. And then the sergeant freaks out and acts stupid. And I turned to him and I said, I'm sure glad you had more personal self-control than your sergeant did. He said, I can't talk about that. I said, that camera you've got up there, is it on? He looked at me, he looked out the window, looked around and said, well, yes it is. Will it turn around so it can see me? He looked out the windows, both sides, reached up and turned it around and said, I've got some paperwork to take care of. I'll be back in a minute. He got up and left. And I dictated a statement into his camera. So they arrested me, let me out without charge, and then I filed a whole bunch of information requests and went to the FBI, and the FBI arrested me because they issued some criminal complaints against me after I filed my information request. So they called me into court. They charged me with a Class A misdemeanor. And the summons, this is a little more than I intended to go into, but I think you'll like this. Has anybody ever been ordered to come to court in a traffic ticket case when there were no motions filed in the case?
Right, they do it all the time.
26.01 or 2801 is the one that allows them to summon you to court. And it has 11 reasons. The first one is for an arraignment hearing. The next 10 all go to motions in one type or another. So there must be motions before the court. Well, that's okay. You go to 2601, arraignments. 2601 says, an arraignment may be held in the matter of a felony or misdemeanor punishable by imprisonment. Now, why the legislature went to special purpose to eliminate Class C misdemeanors, I have no idea. But they did. I went to South Lake, Texas, the highest per capita ticket rate in the country, in the state, with a guy who drove a truck, worked for a friend of mine. And I was going to go in, they sent him in to talk to the prosecutor, and I was going to go in with him. And the bailiff walked up and said, Mr. Kelton, you can't go in there. How do you know my name? Oh, Mr. Kelton, everybody here knows your name. Oops. So he wouldn't let me go in there. I said, I'm going to go in there, I'm his paralegal. He said, I need to get my sergeant. He got his sergeant. So they wouldn't let me go in there. So I asked him, is the judge in the building? Oh, no, he's not. Who's convening these hearings? Oh, this is just to talk to the prosecutor. Is that a fact, Jack? It was the prosecutor's first day on the job. She's 26 years old, just got out of law school. I filed 58 felony charges of simulating a legal process against her with the JP. Welcome to the deep end of the pool. If you've been summoned to court in a traffic ticket and there are no motions before the court, that's simulating a legal process, and it's felony in the state of Texas. I have a traffic ticket site that, I moved it to a new server, so it's down at the moment, but I've got it up, but some of the parts aren't working. If you get a ticket in Texas and you go to that site, you put in the ticket information, it'll drop you down about 150 pages of documents to file. It'll make them crazy. And the purpose of the documents is to get them to ignore them. Never ask a public official to do anything you want them to do. When they ignore them, then you pull out Packard v. Walker. The judge has no discretion in properly applying the law to the facts. When he denies all your motions, the first one is a challenge to subject matter jurisdiction. Here's one you guys will really like. The only people who can enforce the transportation code in the state of Texas are DPS. And a sheriff, he's chuckling because he knows where I'm going.
Yep.
And under 701.001 through 003, a county commissioner's court can certify a sheriff's deputy as a traffic control officer. But he must be paid by the county commissioner's court, and he has to ride a motorcycle. It's right there in the code. I went to, Tarrant County doesn't have any traffic control officers. Municipal police officers have zero authority to enforce the Texas Transportation Code. Zero. So, last time I got a ticket in the county I lived in, this sheriff's deputy pulled me over. Mr. Kelton, you know why I stopped you? They were actually trying to keep me from getting to a court. I was helping a guy in court. I followed that deputy into town, and he veered off to go to where this guy's house was. So I went straight and come in from the backside, and he's sitting there waiting for me. He said, you know why I pulled you over? I said, no, but I'm sure you're going to tell me. Well, your registration is expired. I said, only 2 years? What's the problem? He went back to write a ticket. I called 911. I want him arrested for first-degree felony, aggravated assault, 2202B2A Texas Penal Code. First-degree felony. He came back with the ticket, and he was so furious his hands were shaking. Guy's got no sense of humor. I saw the district attorney in the courthouse about 6 months later. The one I just filed a suit against. I said, James, when are you going to bring my ticket up for a hearing? Oh no, Mr. Kelton, you're not going to get to have your fun with me. Chicken. Actually, I said chicken shit. But this is what you can do. Once you've done this to them a time or two, you can't tie a sheriff's deputy in Wise County up and throw it at you.
What's the name of the traffic website and Can you get in trouble for calling an emergency number when you're at the courthouse for a failure to file a document?
No, failure to file it. Where they don't let you file a document?
Yes.
Well, that's a Class A misdemeanor. You're witness to a crime. But if you're concerned about that, before you go in, get the non-emergency number to the Sheriff's Department. But I have never had any problem calling 911. In this case, a couple other cops showed up. And one of them is on the passenger side, and I'm talking to him, and he said, well, you can get in trouble for calling 911 when it's not an emergency. I said, you kidding? That's a first-degree felony. This is an emergency. He's rolling his eyes, and he's not happy, but there was a third cop there. And this third cop was from the next town over, but he used to be a cop in the town I live in. And he told him, he warned him, because about 3 months before that, I had a niece who was getting a divorce, and the husband was acting out. And I filed a criminal trespass against him with the chief of police, and the chief of police refused to give it to a magistrate. That's what he told me. I said, well, why didn't you? He said, the county attorney told me not to. I said, wait right here. Don't go anywhere. I'll be right back. I got my car. I go to Decatur. James Staten, the county attorney, met me in the hall. And he said, Mr. Kelton, I know why you're here. And do you think I'm out of my professional mind? Do you think I would waive my sovereign immunity by giving legal advice to the police? I said, I don't know, James. I'm just following the thunder here. So I went back to the police station, knocked on the door, and this cop opened the door. And he's grinning from ear to ear. What can I do for you, Mr. Kelton? I said, tell the chief that James Staten just threw his butt under the bus, and I'm here to run him over with it. He said, I'll let you in on one condition. I said, what's that? You let me watch. Watch heck, take movies. Okay, we can do this.
The name of that website for the traffic?
Trafficticket.website.
How long have they got to take you to the magistrate if you've been arrested?
Okay,
Immediately.
I'll fix that. He asked, how long do they have to take you to a magistrate? Well, there are rulings out there that say that they must get you before a magistrate within 48 hours. So what the prosecutors have said, you can hold him for 48 hours. But no, that's not what it means. In the Boyd v. State, a 1945 case, a guy's cutting a road with a maintainer. The owner of the property comes out and tells him stop cutting the road. He said, I can't. My boss told me to do this. If you don't stop cutting that road, I'm calling the sheriff. He said, you're going to have to, because I'm not going to quit cutting the road. So the sheriff comes out and tells him to quit cutting the road. He refuses. He tells him, get in your car and follow me to my office. He gets in his car, follows him to his office. 45 minutes later, after he talked to the guy's boss, his office was 25 miles away in Corpus Christi. He talks to his boss and he said, we got this all worked out, you can go. He sues the sheriff because there was a magistrate 5 miles away. And he took it to his office 25 miles away and not directly to the nearest magistrate. Roberts v. Bohack says that an officer's only defense against a charge of false imprisonment for failure to timely take before a magistrate is a showing of due diligence and effort to locate. What that 48 hours goes to is prima facie. If the officer can show reason why he couldn't take you to a magistrate immediately, but gets you to a magistrate within 48 hours, the presumption is that the taking was timely. So the accused has to show why it wasn't timely. If it takes more than 48 hours, the presumption is the taking was not timely, and the jurisdiction has to show why they couldn't get him to a magistrate before 48 hours. Does that make sense?
Bohack, is that Bohack?
BOHAC, I believe. If you can't find it, send me, it's in the lawsuit. And the lawsuit is on, if you go to jurisprudence.website, documents and blanks and documents and research, November arrest down there, the suit is in there, and Robert's B. Bohack's in there. If you can't find it, just send me an email and I will email it to you. Any other questions? Please, Mike.
You looking at me?
Once you stir up all the stuff, and you're in the courthouse and they're not doing what you ask, how do you follow up?
This is what we call the routine. I run the routine on them. You know, got this rule, never ask a public official to do anything else you want them to do. When they don't do it, like I asked the bailiff to arrest the judge. When the bailiff doesn't arrest the judge, then I make up a criminal complaint against the bailiff and take it to another judge. And when that judge refuses to act, you know, the magistrate will say, oh my, you really should take this to the sheriff's department. And I tell the magistrate, oh my, thank you very much for your sage advice. And I go to the sheriff's department. And I file a complaint against the magistrate. And then the magistrate says, oh my, you need to file this with the district attorney. Oh, okay, thank you very much. You got the routine. You walk it all the way up to the top. What I was doing when I went to the Chief Justice, I was walking it. This time, generally I go from the bottom to the top. This time I went to the top and was working my way to the bottom. I can file criminal charges against the highest level judge in Texas just as easily as I can file against the lowest level judge in Texas. To me, I'm the master of the sermon. There is no difference between those two. That's what makes you so dangerous to these guys. This information they absolutely do not want you to do. And once you start doing this, and a lot of people are afraid, well, won't they come back and get you? No, they won't. These guys are cowards. That's not really fair. I know a number of policemen. I don't know a single policeman who became a policeman so he could be a jackbooted thug. They want to be good guys. They get into this business and find out it's not anything like they thought it was. Lawyers the same way. They want to help people. They get out and they find out the only thing they do is try to get retainers. They get your retainer, and then they go through what Dr. Graves in Jurisdictionary calls a flurry of motions at the beginning of a case. They got all these motions made up already. They know all the case law already. They don't have to do any research. They hate doing research. Westlaw ruined the practice of law, and we don't have time for that here. But, they destroyed the practice of law with these search engines. But the lawyer doesn't want to do legal research because the worst mistake a lawyer can make is to miss something. He can win the case, but if he doesn't win as much as he would have if he hadn't missed something, his client can sue him for what he missed. And judges can sanction lawyers at the drop of a hat. They are terrified of judges. So they want to get your retainer. They'll feed you this story, all these great, wonderful things they can do until they get the retainer. Then they do this flurry of motions back and forth. And when they use up your retainer with these motions, then they come to you and they want 3 times the amount. Oh, this is a lot harder than I thought. You know. But we're going to need, instead of 5,000, we're going to need 15,000. He doesn't want to get 15,000 from you. He wants you to go somewhere else because he doesn't want to have to start doing research. That's how it works in the world we live in. So that's why you sting the lawyer on the other side with bar grievance. Now he's worried about me stinging him. When they arrested me in Austin, they called me in for a hearing, and that's why I went to 2601 and 8. They called me up, and I started a little stink before that. The clerk wanted to ask me questions. She called me up. She said, "You're in Kelton?" I said, "Yes, I am." I said, "I have some questions." I said, "No questions." "Well, I have to ask you some questions." "Well, you can ask what you want to. I'm not going to answer." She said, "Why are you here?" I said, "I want to see the judge." "You can't see the judge unless you answer my questions." "I'll see what the judge has to say about that." She said, "I need to get to security." "Yes, ma'am. As a matter of fact, you do. I'll be sitting right here." So security comes up, but somebody tattled on him. He knew who I was when he got there. He could not have been nicer. "Now, Mr. Kelton, what seems to be the problem?" I said, "Well, the problem is I don't know if I need you to arrest the clerk for impersonating a judicial officer or the judge for official misconduct." "I'll be right back." Well, the judge decided to see me, and they called me up, and her name was Elizabeth Earl. Her father was Ron Earl, the 25-year district attorney. The district attorney's office is in a new building now. It's called the Ron Earl building. Well, I figured she was pretty political, so I stopped giving her a hard time. She said, "Mr. Kelton, are you Mr. Kelton?" I said, "Yes, Your Honor, I am. I have this summons here, but it doesn't tell me why I've been summoned. You want to tell me what I'm doing here?" "Well, Mr. Kelton, we need to find out if you had an attorney." I said, "Your Honor, I got 28.01. It lists all those things you can call me to court for. To see if I have an attorney is not one of them." And my court watcher said he could see the muscles in her jaw working. And she said, "Well, Mr. Kelton, we needed to know if you have an attorney." So I decided, since she was political, leave her alone. And I said, "Nope." She said, "Are you going to hire an attorney?" "Nope." "Would you like me to appoint you counsel?" "I don't care what you do." She said, "Well, Mr. Kelton, I'm going to appoint you an attorney." I said, "Well, if you do, make sure you appoint one you really don't like." And she kind of laughed, because she knew who I was at that time. And said, "Well, I got an attorney wheel. You get the next one off the wheel. So you're off the hook." "Yes, I am." So the attorney comes out, we go in this room, and he starts this is how things are going to go. And I let him run on a little while, and I said, no, that's not how they're going to go. He said, "How are they going to go then?" I said, "This is how they're going to go. You're going to go to the judge and ask the judge to remove you from this case. And I'm going to go to the judge and tell him, don't you dare remove him from this case. He's my counsel of choice, and he's under contract." And the lawyer said, "Well, Mr. Kelton, I'm under contract with the state, not with you." "Yes, you are, but I'm the intended third-party beneficiary, and I have standing under the contract. And the judge is going to remove you from the case." And he said, "Yes, he will." Then I get to sue the judge for interfering with a private contract. And he got this look on his face that said, "You're going to get me disbarred." And then I told him, I have some motions before the court, and I have 19 felony and misdemeanor charges against public officials involving my charge and arrest. You will adequately adjudicate every single one of them. You fail to adequately adjudicate a single one of them, I'll bar review. He sat back, "Mr. Kelton, you would grieve me in a heartbeat." So he's terrified I'm going to bar review. We're in court. He's up at the bench with the prosecutor. I'm outside the bar. He come over to me and he said, "The prosecutor said she knows who you are, and if you start filing criminal charges, she's going to charge you with tampering with a government document." And I looked over at her. "She said that, did she?" "Yes, she did." "Well, get her over here." And I pulled 30 of them out of my case. I said, "I got 30 of them here. Get her over here." "You, get over here. I need you to verify these criminal complaints." She scooched up against the bench like the judge would protect her, and turned to the lawyer and handed them to him, and held up both hands with his palms out. He said, "I'm not going to touch him. I'm not going to touch him. Take him, you chicken shit." And the judge banged the gavel. Recess for lunch. Before I could get my taco, my lawyer called me, and he was ecstatic. The judge dismissed the case. Probably the first case he ever won. So, being the kind of understanding guy I am, I said, Well, did he dismiss it with prejudice? Oh, Mr. Kelton, get back in there and make him dismiss this thing. Oh, Mr. Kelton. Ah, just kidding. If you want your lawyer to work in your favor, you have to give him plausible deniability. I put my lawyer in a position to where he can fight my case and not be in trouble. Did I mention here the four-sided chessboard? He was stuck on that board, and I got inside those relationships. Judge, he's going to ruin my career. You got to help me out. I'll pay you back on the next one. This is how it really works in the world we live in. Once you understand the political side, you become bad news. And we can really change this. That's my story, and I'm sticking to it. Any other questions?
I got a follow-up. So primarily your deal is to file charges against everybody that gives you an excuse in hopes that they dismiss the case?
Well, that's part of the strategy. I couldn't go through everything here. Every time I go into court, I always have a purpose, and it's different depending on what the issues are. So, first thing you do is write down what your intended outcome is. And the rest of it will flow from that. You won't, it won't be hard to figure out, who you want to beat up, who you don't want to beat up, depending on what you want at the end of the day. There is no prescription. The best fight to have is the one you pick. So go pick a fight. I got a guy in California. He went down to the city to pick the fight with him. He sent in some information requests. And if you craft your information requests artfully, they'll screw them up every time. And that's Class A misdemeanor. The fight's on. You will be amazed at how much fun it is. You're used to them coming after you, your liberty's at risk, and it's horribly depressing. I once defended myself in Cherokee County with all my knowledge. Oh yeah, nothing to it. I had to force myself to write a document. I was amazed how difficult it was. But when I go after him, I handled myself so well in court as the most outrageous nonsense charge you can imagine. I got the jury to throw the book at me. They sentenced me to a year in jail. I filed 35 criminal complaints against the judge, and 2 judges, and the prosecutor, and everybody. In 2 days I was out.
I got 2 tickets, no driver's license, no registration. I go into the JP court and ask her to prove she has jurisdiction over me, and she says she has jurisdiction and immediately starts the trial. I lose the case. They only found me guilty on one of the charges. I appealed it to the county court. The first thing I did when I got in county court was ask the judge to prove she had jurisdiction. She said, I have jurisdiction. And when she did, I said, you just committed fraud on the court. And the sheriff jumped up, put his hand on his gun, and threatened to take me to jail until he
First degree felony aggravated assault.
That's what I'm thinking.
Charge him and the judge both with it.
Oh, I'm going to get them all.
But never do this with your mouth.
Right.
Never make a proactive statement of law out of your own mouth. You can challenge jurisdiction verbally, but you should do it in writing.
I did do it in writing as well.
Okay, then go after the judge criminally. The judge can't say, I have jurisdiction. The judge has to
The
prove
case
that
has
she
to
has
stop
jurisdiction.
immediately until they prove it.
And go on trafficticket.website. If it's not working, send me an email. I'll send you that subject matter jurisdiction challenge. They can't get past it. And then go after the judge, sue the judge and the sheriff.
Okay, now then what? a follow-up question to that. After I appealed it to the Third Court of Criminal Appeals, they kicked it back to First Court. But my question is, once it's been appealed up,
Wait a minute. You said they kicked it back? What does that mean? Did they ruin your
I
vote?
filed it in the Third Court of Criminal Appeals because that's where they told me to file it. And then I filed it, and then they transferred it down to First Court of Criminal Appeals.
Oh, okay, that's just moved the venue, okay.
Yeah.
So they haven't ruled on it?
No, I'm waiting on it. They were supposed to start considering it the 16th of last month.
Well,
They still hadn't done anything.
Well, expect 5 to 7 months.
That's cool.
Yeah,
I can handle that, but do I need to wait until they make a ruling to file charges against them?
No,
Everybody involved.
absolutely not.
It makes no difference whether you're guilty or innocent. They acted without subject matter jurisdiction.
Right.
Yeah, so criminal is totally separate from civil.
Yeah.
It's totally separate. If you're in a criminal case, the criminal charges you file are totally separate from your criminal case. So you never have to wait.
Okay.
And don't wait. Go after them like a firestorm.
Ladies waiting.
Thanks.
You're welcome.
Okay, Randy, I don't know if you know the answer to this. I'm talking about Texas Penal Code 2503 right now, the family code. And I'll just give you a little short,
Okay, can
is that what
you
they call it?
tell me what it says?
It's the family code, like custodial interference.
Okay.
Custodial interference, where if someone kidnaps a child or withholds a child from another parent. So in mine, my lawyer in Tarrant County filed a notice of, I paid him the retainer, $3,000. That was the first of 140,000, but not to him, but $3,000. He said, I'm not going to file the notice of appearance. I didn't know what that meant. I hadn't really been to court or, a whole lot. And I go, what are you talking about? And he says, you'll see, but don't you want your jurisdiction to be in Texas? I said, yeah, because I'm going to see my kids if it's in Texas. But if it goes back to Iowa, where I'm from, I'll never see them again. So, unbeknownst to me, he doesn't file it, but he goes into the court without me. I'm in bed. I have no idea this court's going on. And the judge sends my jurisdiction to Iowa. So I go in for another hearing on a notice of indigency because I couldn't afford all this. And the judge says, well, I sent it to Iowa. I said, I know, I'll never see my kids again. He laughed at me, basically.
Hold on. This is way too complex. This venue.
All right, so,
Write me up a timeline.
yeah, I've already done that.
You can't write a timeline. You can't
I have.
adjudicate your case. Let me tell you what I do on my show. I get a lot of people calling in. Ostensibly, they're calling in for remedy, but most of them are not. Most of them just want to be heard. And that's okay so long as that's the reason they come. So I ask for a timeline. If you can't do a timeline, you can't fight your case.
I've already done it. I've got a
It's
timeline
hard.
from the year
It is.
2000 up to 2018.
It is the hardest thing you will do, but it is the most valuable thing you can have.
So let me ask you this might be quicker. Since I lost my children to this abuser because of what took place, and the PTA lady from the school basically coerced my children into getting in an airplane, going to DFW, the DA never prosecuted the 2503, the custodial interference, saying he's the dad, he can do what he wants, but the PTA lady's not the dad. I've brought that to this lady, Sharon Wilson, twice.
Yeah, I know Sharon Wilson. I interviewed her on my radio show before she became the DA. If the person was acting with the father and the father was not technically in violation of law, she wasn't either.
Even though he was not on that court order at all. Because he'd already kidnapped my older two children prior.
Can't answer these questions, way too complex. You said that court order. I don't know what court order, I don't know how it was said. Way too many variables here to be able to give you any kind of reasonable I'm sorry, this is complex.
I know.
When you get into one of these fights, it's extremely emotionally draining. When I was defending myself, I could not believe how hard it was. I did not want to even touch a document. I had to force myself. I understand this is horribly difficult. That's why I asked
Yeah, I've
her.
got 6 totes and 4 drawers full of hell paperwork, just like all the other parents in my situation. There's over 30 million of us.
If you can't create a timeline, everything else is just complaining. You won't be able to fix it. It's hard. You'll have to struggle.
I have not only the timeline, Randy, I have a list of bad actors.
Okay, yeah, that's what
I've got it all.
I can't intelligently answer questions here because there are too many variables involved.
Okay.
I try to be careful and not give bad advice. In 15 years, nobody's ever went to jail. Nobody's ever lost a case doing what I tell them to. But I am careful, and I'm sorry I can't give you more.
I got one more question. The district attorney in the case that we were talking about, once I appealed it to the appeals court, the district attorney sent 2 laws and recommended that the judge look at them. Is that legal?
Yeah. He's been directed to give legal advice to the lower courts, so absolutely he can do that.
The attorney can give it to
Anybody
the
can.
appeals court?
Yeah, both attorneys are required. If the judge makes a mistake under the American Bar Association standards, the lawyer is supposed to notice them, tell them about it.
The lawyer didn't mention it being a mistake, and he didn't say anything about it. He just listed 2 laws for the judge to look at.
Yeah, he can do that.
Okay.
That's not ex parte. If he didn't speak to any of the facts in the case, it's not ex parte.
Okay.
Come on, go ahead and answer that question.
It sounds awful difficult.
It's difficult the first time, but once you've been through it once, pick a fight. It's a whole lot easier when you pick the fight.
Well, I'm better at physical fights.
Yeah, you don't get to. I'm a combat veteran, and
That's it.
I want everybody to have guns, but I don't want one around me. I spend way too much time on the shoulder and I've had all that physical fight I care for. This one's a lot more fun, and you don't get as many broken bones, 3 dislocated ribs, two broken collarbones, tooth knocked out, a broken elbow, and that's doing this. I got better at it. Now I don't have to have those. I avoid those physical interactions. It's better to take them on with their own rules.
I like to take them on my turf instead of theirs.
That's the way you do it. Set them up.
Yeah, on my land, at my house. Confrontations are a lot easier than that.
Yeah. If you get too violent, it gets ugly anyway. The better way you're doing it, more.
Oh, no. It's just
There's people waiting to ask questions.
trespassing then at that point.
Then you call the sheriff, and when the sheriff don't want to arrest them, you call the sheriff on the sheriff.
Or maybe the U.S. Marshal.
Well, if they get federal, yeah.
There's people waiting to ask
Any other
questions.
questions?
Oh, okay. Code enforcer, city threatener,
Low-hanging fruit.
low hanging fruit. You pick a fight and don't do what they threaten you to
Don't
comply with.
Tell them not to come on your property unless you got a warrant.
Oh, they don't. They drive by and send threatening letters.
Oh, okay. And every time you get a threatening letter, file a professional conduct complaint against them.
Where do you file that at?
It depends on who, if he's a code enforcer, you file it with the mayor. Send a tort letter to the mayor, threaten to sue the mayor.
Okay.
The mayor's low-hanging fruit. The code enforcers are used to doing what they do, and people shaking their boots. And we have an argument for code enforcement. The legislature was authorized by the Constitution to write law. The legislature was authorized to create courts, and they created municipal courts in various cities, and they created some statutory courts around the state. But they weren't authorized to, what's the word? They can't authorize somebody else to delegate. They can't delegate their lawmaking authority. You notice that they're accusing you of violating ordinances.
Ordinance and code.
You ever wonder why they call it ordinance and code instead of law?
Ordinance is ammo.
It ain't law. Because they can't pass law. Only the legislature can pass law if the municipal corporation creates ordinances. Those are corporate bylaws. If you're not in contractual privity with the city or the county, where you have agreed to abide by all of their bylaws, and they try to apply that to you, then that becomes a law. Only laws apply to the public. So I've got a pleading on that argues the constitutionality of ordinances, and here's the problem. You want to bring an issue that they do not want to risk a court ruling on. If they come after you and you say this is not a law, if you treat it as a law, then I sue you, we take this to the courts and see what the courts has to say about you trying to write law. Now, their lawyers are going to look at that and say, Bubba, if he gets a ruling in your favor, or in his favor, you are screwed. You do not want to get this to the courts. So, send me an email, randy@rulelawradio.com. I'll send you this pleading. You'll love it.
Okay, thank you.
I've got one question. We're always, I want to cut off the food. Okay.
Real quick, you said read all the codes. So you're talking about the Texas law, the big book, or what?
Penal Code, Code of Criminal Procedure,
So that's the book I need.
and then Rules of Civil Procedure.
Is that on your website?
No, but I'll put it up there.
Okay. Thank you. That's what I was wondering.
The criminal laws, the criminal code, the Code of Criminal Procedure, that's procedure in criminal cases. That's a subset of the Rules of Civil Procedure. So whatever is not addressed in the Code of Criminal Procedure, then they use the Rules of Civil Procedure. The criminal procedure doesn't tell you how to file a motion, how to get it set for hearing. All these little technical things. The criminal part only goes specifically to criminal issues. So these two are both part of the same. Like you've got family law and you've got other laws, you've got criminal. There will be special rules for each one of those. But the rules of civil procedure apply to all of them. So rules of civil procedure, code of criminal procedure, and penal code. They're not as big as you think.
Okay.
And they read, once you've read through them twice, you'll know these codes better than the lawyers do.
Okay, I'm going to give it my best shot. Thank you so much.
Okay, the book that you're passing around here, is this on your website, the petition for declaratory judgment, is that on your website?
It is in the B. I think so. If it's not, I'll make sure it is. Petition for declaratory judgment, I think that's the first half of my lawsuit. Let me see. They won't get out of here. Oh, I didn't explain what petition for declaratory judgment is. Okay, this first part of the lawsuit.
And that's on the website?
next time.
Is that on your website?
Anybody who can, seminar next year.
Is the lawsuit on your website?
Yes, that, look at the lawsuit, look under November arrest. It's in that.
Thank you.
For anybody interested, I'm doing a seminar in Austin next Saturday. I don't have a venue set quite yet. I may have that by the time I get home. And anybody who's interested, send me an email and I'll put you on the list. I will be doing seminars. The next one I want to set up, it'll be a full day seminar. The next one I want to set up here in the DFW area. And I go through a lot more. I go through this in a lot more detail. Okay, thank you all. I'm going to give him the microphone.
Thank you.